and come back the following morning. This is where the issue of sanctions comes in.
So what do you do with them?
You deal with them. You warn them. Firstly, you start by talking to them. Mm-hmm. You counsel them. You tell them that here there are two things. One, there is a return for capital. Mm-hmm. We are paying you. You must give us A, B, C, and D, and that is your contract. Mm-hmm. So if you are not able to work on that, we may be at war sooner or later. So you start by counsel. You go to warning. You go to evaluation of the results. Mm-hmm. And if the worst comes to the worst, you may have to now come to the contract and say, now, we agreed on ABC. You are producing X, Y, Z, or nothing. Mm-hmm. This is what is going to happen. That is going called a departure in employment law. So the other one is a reward. Those who do well and exceptionally well, like myself, the JSC should look for ways and means of decking us over Christmas, over Easter, and you deal with us nicely, because we are not only setting a good example to the others, we are not only pulling them up, we are telling everybody that it is doable. You must not necessarily be an idler.
Thank you, Judge.
We have the acumen to do it.
Thank you, Judge.
Thank you, sir.
Your Honor, I think the Commission has heard that request from you. Commissioner Koskei, please go ahead.
Thank you, Chair. Good afternoon, Judge.
Good afternoon, sir.
Supreme Court Judge and resource mobilization. You are now walking into Supreme Court as a judge, and judiciary generally have limited resources. However much the government wants to allocate, there are a lot of competing needs in the country, and therefore many institutions look out to development partners, their international networks, to see how they can raise funds to support some activities in their institutions. Would you tell us how, as a Supreme Court judge, will you help the head of judiciary to mobilize resources so that the services that judiciary renders to the public are done efficiently?
To be honest, this is my weakest area. I do not believe in begging whatsoever. However, we have our conditionalities and our situations here. Donor funding has moved us this far, not only as a judiciary, but also as a nation. I may not be very good at that, but we have what we call delegation. I may have the ideas. Don't set me to the forefront, because that may not be very, very good for me. But we have other people who can do this. I may have my tentacles upright and identify areas where we can seek funds, and we know them. So it is not personal. In as much as I may not be a beggar or may love begging, I know where we can go, and we can send other able-bodied people and able-personed people to do this. In the absence of that, if we didn't have them here, and I believe we have so many of them, we can hire these fundraisers, and they will be able to do that for us.
Thank you, Judge. Let us now go to performance. There has been an effort to introduce performance management in judiciary, and there has been an equal measure of resistance or perceived resistance, especially from judicial officers, where they say you can't measure, you can't dictate to how or when should I, finalize my activity, whether it's a case or whatever you are handling, to the extent now that it is very difficult to make the institution as efficient as expected, and more difficult to measure. The metrics that are always used for institutions in as far as service delivery is concerned becomes a bit difficult. What are your thoughts on introduction of performance management in judiciary, and how can we mainstream and entrench it so that each and every worker or employee of judiciary embraces it for the betterment of service delivery?
Thank you for that question. Let me start by saying that performance management is a part of us today. It has been there for the last 3 or 4 years or slightly more. And the issue of resistance was the old day thinking or mentality of judicial officers. Not anymore. I have not seen any resistance from anybody, or from any quarter, at least not any which is noticeable or physical, which you can be able to see. We are all in it. And those of us who are well-intended are fully in it. We may have small circles of resistance, like you are saying, or unwillingness, reluctance to embrace performance management. But to those, let them be warned. I come from the labor and employment and labor relations circles. I'm an expert in that area. A contract becomes a contract. When you come here as a judicial officer or by any other definition, as a worker for the judiciary, you don't come to do your things. You don't come to dictate terms. You come to do that which your employer requires of you. And if that is part of it, you have no choices. Number 2, we are just being archaic. Archaic in the sense that we resist measurements of what we do, then we must be clandestine or something to that extent. Everybody from day one, when we used to go and weed other people's chambers, you are given a portion. That is for 10 cents, that one is for 50 cents, and you weed the whole piece, and nicely it is evaluated, and you are paid your 10 cents, not 10 bob. 10 bob was for a whole month in our time, or your 50 cents. And that is where we are. That is what every worker, every society which wants to make a sense of work must embrace. Those small circles of resistance, one must be crushed by any other means, not physically, of course. We must talk them out of it. Number 2, we must be able to realize worth. We pay you, give us the worth of that pay. It's a matter of exchange. That is why it is a contract. So we cannot negotiate that, good Commissioner. Everybody must be measured. That way we'll be able to do our best, optimize, clear backlog, make Kenya free, liberate our economy, and liberate everybody else. I mean, we have people who walk in court every other day because I don't want to be measured. Nothing.
Thank you. My final question is, I've gone through your CV and I saw Kirigi attended primary school. You founded Kirigi and you stated that it was community service. But I see that you saw some opportunity to do business. Is it community service, really?
Good enough, good enough.
You got a chance to do business by establishing a school in your county.
Thank you. That is a very warm question. Kirigi Tented Primary School starts on 6 acres, which belongs to my family. The lower side of the river Rogoti is a forest which I've done for humankind. Everlasting forest, the equivalent of Mount Kenya forest, which is about 1.5 kilometers from Kirigi Tented Primary School. Kirigi Tented Primary School was my idea of return to society. From day one. I mean, I never went to school on my own. I mean, my dad and his good friends would contribute or sell a cow or two and take me to school. In this status and being so endowed, I thought the best thing was to advance education in that place so that everybody is able to get a chance to get to Alliance High School or any other golden high school in this country as of right, like I did. And that's how I started Kirigi Tented Primary School. I've run through Kirigi Tented Primary School with lots of difficulty because of the confusion of politics and a few other things. But we stand. Kirigi Tented Primary School is there. We charge some little fees. We pay the balances from what you pay me. And I am very, very comfortable. Kirigi Tented Primary School was born out of an idea to do all Kajiado University I only went to that level when I realized that you cannot start up there when the young boys and girls of Kirigi, where I live, are not even able to get quality education. That is a private partnership where my family or our family has decided to invest in society. Principally, I believe in that. I am doing it, and more often than not, you find kids there who have been promised that between where they are to infinity, PhD and beyond, my family or our family will be able to meet their expenses, walk them throughout the school if we can afford. And if we can't afford, we may be able to, through our interactions with everybody else, be able to get them that far. We are trying to enhance a society, we are trying to enhance Kenya, we are trying to enhance humankind at our expense.
Thank you.
Thank you.
Thank you. Thank you, Judge. Thank you, Chair.
Thank you very much, Commissioner Koskei. Commissioner Olrede, please go ahead, it's your turn.
Good afternoon, Judge.
Good afternoon, how are you?
Fine, thank you.
We thank God.
Do you believe that we have instances of abuse of judicial power? And if you do, please tell me how the Constitution seeks to check abuse of judicial power.
Yes, we have instances of abuse of judicial power. Thank God, post 2012, this has come to very reduced levels. We do. How does the Constitution now come in to check on this? The Constitution is very, very clear that judicial authority belongs to the people of Kenya, and we are just, agencies for Kenya in this kind of exercise. All powers, let's start with sovereignty. Sovereignty belongs to the people of Kenya, collectively. So every of us who is a state officer or who works in the public sector is just an agency for the people of Kenya. You are on borrowed authority. So you cannot go there and imagine that you are in charge, you are the ruler. The ruler mentality has been overthrown by the Constitution of Kenya 2010, and any other constitutions generally don't accommodate that kind of thing unless they are archaic in their thinking. So what we have today is a situation where at all times we are warned that it is not ourselves as the judicial officers. It is not ourselves as workers of the judiciary. It is Kenya. And no more.
That is true, Judge. That is the situation. We derive our judicial power from the people. But what mechanisms has the Constitution put in place to ensure that that power is not abused?
The Constitution of Kenya has put in Article 10. What is Article 10 all about? Article 10 is about the imperatives of a state office are good governance, and these are all elaborated in that article. The issue of equality, the issue of gender, looking at gender, affirmative action, the issue of regional equity, the issue of equity itself, equality. Those are attributes which the Constitution has provided for us to deal with this. There's the article on public service, 232. It gives guidelines as to what a public servant ought to do and not to do. Article 73 on leadership and integrity. It tells us all there is. When you're a leader, like in your position, you're in leadership. I am in leadership. We don't do this on our whims. We are guided, we are controlled, and we are mandated to do that or take off, walk home. Precisely that.
And so also Article 159.
Oh yes, 159, the one which is on judicial authority and the way it ought to be exercised, the issue of technicalities, the issue of alternative justice systems, the issue of fairness, the issue of impartiality, et al.
Thank you.
We are clearly guided. We cannot run away unless you want to offend the Constitution, and if you do, there are consequences. We are in business.
Thank you. Judge, could you please explain to us the mischief rule of statutory interpretation?
Statutory interpretation, if I remember Professor H.W. Kosagodo, then he was a doctor in my first year. It depends on the two criteria. One is the plain words of the write-up in the statute. Two is the marginal notes. Mischief comes in this, the intention of Parliament. It is part of the whole thing. Number three of element number three of a statutory interpretation. But this is where the mischief comes in, because every other time I find you in the streets of Kinangop, you'll be talking about this was the intention of Parliament. This is the spirit of it. etc. Do I repeat? etc. That is where the mischief comes in, and that is where we must be checked and checked, so that we don't abuse statutory interpretation by imputing what Parliament may have imagined or thought, etc. When that arises, and you want to be very, very clear, you go to the Hansard, the debate on that statute. You get answers. If you are not able to get answers, as a judicial officer, you must be cautious, you must be guarded, you must warn yourself that you are treading dangerously. Minus that, it will be chaos all over. Everybody will be coming up with these intentions or imaginations of what Parliament intended. Did I get it right?
I would say that. I won't give you an answer to that.
Don't answer.
But I want to ask you,
yes.
Then what is the golden rule of interpretation?
The golden rule should be the reverse of that. The plain words of a statute. Those ones will give you the meaning. If those don't give you the meaning, that is the golden rule. The literal reading of statute. If that doesn't work, you go to the marginal notes.
Okay, thank you, Judge. My other question concerns surrogacy. In your view, who has parental rights and responsibility in a surrogacy agreement or surrogacy arrangement?
That is where tricks and trickery comes in. A good commissioner of the JSC, but being lawyers, we must answer it in the strict sense of the law. Here we have a contract which involves two people, the surrogate mother and the surrogate himself or herself. So who has parental rights at the end of the day? The law and the reality may be different. And this is where we come in and have to deal with the delicate state of affairs in the relationship. Because the law provides that in this contract, the one who has rights to the child at birth is the surrogate, not the surrogate mother. But we are also getting to
Judge, so that I understand you clearly, when you say the surrogate and the surrogate mother, who are you referring to?
The surrogate mother is the woman who is used to, conceive and bear the child. To me, the surrogate is the contractor.
The one who carries the baby?
No. Good enough, yes. The contractor is the one now who, in reality, is supposed to own the baby when it is born.
Mm-hmm.
So here we are saying the law favors the person who contracted the surrogate mother to bear the kid. But the reality of the matter and the actual, human rights situation comes in this sense that I have contracted to conceive and bear your baby. I have it, and then I start claiming rights in it. So who has a superior right in the circumstances? This is a constitutional issue. It's a matter of law. And if you ask me, I would say ultimately, at the close of the day, the mother is the one who is. The mother has a bigger stake in the entire contract, in the entire matter. We have had a breach of contract in actual contract law. This will be a breach, but ultimately, insofar as constitutionalism is concerned and human rights, the mother would be more entitled to the baby than the contracting surrogate person.
In this case, by mother, you mean the one who
who conceives and bears the kid as superior rights to me than any other person.
Okay, thank you. So in our current dispensation, I know we do not have a legal framework to govern that, but there are cases that have been determined by our courts. In our current dispensation, how does I prefer to call her the prospective mother, the one who asked another to bear the child, to carry and bear the child on her behalf. How does she acquire parental responsibility, assuming there is no quarrel? How does she acquire parental responsibility and rights over the child that is born in a surrogacy arrangement?
This is by way of adoption.
Thank you.
They have to take the kid and walk through that process and get it to themselves legally and in law.
Thank you. My last question will be, can a judge participate in a tender for supply of goods and services to the judiciary or the Judicial Service Commission?
Not a judge only. None of us who work for the Judicial Service Commission or work in the judiciary supposed to have any commercial relationships with either the judiciary or the Judicial Service Commission. This would amount to, in the first place, it would be bad manners, like my good friend Elisha Ongaya would like to put it. Number two, it would be, besides the bad manners, it would be outrightly immoral. And thirdly, it would create a conflict of interest. In fact, I would not like to imagine that that would happen, but if it does, it should be, ostracized to the end of the world.
And do you think there are exceptions to that rule?
I have not found any. I've not been in a procurement. I have not found any. But I would think of a situation where you have expertise in an area which is alien from your employment contract. And this cannot be achieved in any other circle. That time, and when all other factors are constant, and there is a declaration of it is open and transparent, maybe your services, like if we wanted to do a international competition on chess, and we have a judicial officer who is a chess player of international excellence, and this is not his part of the game. It's not his cup of tea.
If I may just interject, the question was if there is an exception to the general rule that you cannot participate in a tender to offer goods or services to the judiciary or the Judicial Service Commission. Are there exceptions to that rule?
I am not aware of any, but they can be there in situations where the matter comes out very, very openly, transparent, and where all parties and everybody else, including the Kenyan public, is involved and warned of what is happening and approves of it. Because the judiciary is the property of the Kenyan public. The Kenyan public must participate in it, people's participation. So in such delicate circumstances, which should be rare, there must be involvement of every other stakeholder, and there must be absolute transparency.
Okay, thank you, Judge. My last question, my final question. Not everyone is good at everything. What do you consider to be your weakness, and what have you done to remedy it?
Now that's a difficult question. My weaknesses, they are rare. Let me give me a little more time to think about it. I'm not, in relation to what I do in the judiciary, maybe not. In relation to, myself, home. Let's get home again and get our short-tempered nature as people from those sides of the mountain. I carry that also, but it is just instant, and it goes away almost instantly. We have realized that you cannot fight it out and win in some of these matters. Matters creation, matters relation, matters which have to involve, because you cannot go it alone. So when such situations arise, and we've taught ourselves over time. It was poor in a primary school. We went through high school. We are now grown-ups. We are getting into into eldership, and we have temperated this so that we are able to cope even with the worst of situations without over-employing or over-emphasizing such a disability.
Thank you very much,
Judge. I could remember very clearly.
Thank you for your honesty. That's all that I have for you. I want to just mention, I think the chair already mentioned that we got the documents that you updated. Thank you for that. They'll be considered by the commission. I wish you well.
Thank you so much.
Chair.
Thank you very much, Commissioner. Honorable Judge, just a follow-up from what Honorable Rod was asking about the contractor, back to the surrogate mother, about the contractor of the service and the surrogate mother, and you said that at the end of the day, the surrogate mother has the right. So my question is, Judge, if there's a contract, does that mean that contract then is not binding, or what is your view?
Contracts, those of us who have reminisced through the law of contract are not proof. There may come circumstances which make it impossible to effect the contract. There is also what we call a breach of contract, and in a breach of contract, the remedy is restitution or compensation for what you've lost in the game. In the instant case, we are not looking at the contract is not the primary issue. What is the primary issue is the human rights issue. The mother of the baby vis-a-vis the contracting parent. So if you look at that one and you get that it is not feasible, if the mother decides to make an about turn, it will not be, total denial, it will just be breach of contract, and it's a compensatory. The other party can get what they ought to get insofar as the breach is concerned, and we cure the bigger issue, which is the human rights of the baby and the surrogate mother.
Okay, thank you very much, Judge. And we now come to the end of this interview. Your Honor, we want to thank you very much on behalf of the commissioners for coming for the second time and talking to us. Do you have anything you want to tell us, Your Honor?
Firstly, the card is here. Should you choose to look at it, it is available. Secondly, we would wish to thank you so much for awarding us another opportunity to come and have our feel of the two very principal vacancies available in the judiciary. Now it is one, and for that we thank you. We thank you for your cordiality also, the openness, the heartiness. I only missed the bit of my good friend. He may want to deny me at the hour of need, but we've always been friends. I should have been there. Next time we come to the commission to the commission for this kind of exercise, let's have you, my good friend, Commissioner Wasame. Give me an opportunity also to thank those who have been with us in this matter, particularly my referees. They added the references to me. That was very, very kind and very accurate. I would thank them. My global fans, fare thee well. Another moment will come, and we shall be there. Thank you so much, good commissioners. Thank you so much, Chair of the Commission. Thank you, and may God gladly and mightily bless you all. Bless the judiciary of the Republic of Kenya. Start with the Republic of Kenya. Oh, God's grace and blessings. The judiciary of the Republic of Kenya. Every other grace and blessings. The Judicial Service Commission. All the time. What we don't remember when we come here is that we shall always need the judiciary. We shall need the JSC. And we must always be very, very careful how we address ourselves in circumstances like these ones. Thank you so much. It's been a great honor. Welcome.
Thank you, Judge. And once again, we have learned a lot from you too. And we have noted for record that the disability card now is on revision. And we want to thank you for correcting that error, Your Honor. So thank you very much, commissioners. And you can give back the